Hi everybody, welcome to the sixth video for Legal Studies 3-4. This is the final video for Unit 3 and so the final video for Unit 3 Area Study 2. This video will cover case management powers, alternative dispute resolution, remedies and reforms. Case management powers are outlined in the Civil Procedure Act and the purpose is to facilitate the just, efficient, timely and cost-effective resolution of issues in the dispute. So judges have two main powers under case management powers. They have the power to order parties to mediation. So as we'll learn in the next couple of slides, mediation is a more cost-effective and efficient dispute resolution where parties reach an agreement themselves and therefore are more likely to accept it. Judges can order parties to mediation. It usually occurs prior to trial. However, it can be in the early stages of trial as well, if there are prospects of the parties being able to reach an agreement themselves. The main reason that judges order parties to mediation is due to the cost savings and time benefits to parties and also in saving court resources. Judges can also have the power to give directions, which are instructions to either one or both of the parties, which imposes an obligation. If the parties do not comply with the obligations, then they can be held in contempt of court and be fined. The purposes of these two powers are to streamline the case and minimize unavoidable delays. So mediation, as we said before, reduces delays through more efficient dispute resolution, whereas directions can be imposed to set timelines to the dispute so that issues are not drawn out unnecessarily. The judges can also limit the number of witnesses or documents to ensure that only relevant evidence is tendered into the court. The judges can also determine adverse cost orders and determine how evidence should be presented in order to reduce those avoidable delays. And with adverse cost orders, that's just another type of direction, not so much about the delays, but more about the closure of the trial once it's been resolved. The first type of additional dispute resolution that you need to know is mediation. So mediation is where an unbiased mediator facilitates discussion between the parties and ensures that both parties have an equal opportunity to argue their sides of the dispute. So the third party only facilitates discussion by asking questions like, do you have anything to add to that? Or is there anything you would like to respond? Or how do you feel about that? So that the parties talk through their issues and can reach an agreement themselves. This allows the parties to reach a mutually agreeable compromise. However, the decision is not binding unless a deed of settlement is signed. Mediation is beneficial as it reduces costs, time, and inconvenience for parties. Mediation is used by courts, as we learned before, through case management powers, VCAT, and VCAT's short mediation and hearing for civil claims of less than $3,000. Mediation is suitable where parties want to maintain good relationships because parties can reach an agreement themselves and be comfortable with the resolution of such a dispute. However, it's not suitable where there's animosity and conflict between parties or an imbalance of power where one party is going to overbear the other in discussions. Conciliation is the next type of additional dispute resolution that you need to know. This is where the third party is slightly more involved than mediation, as they can provide solutions. However, the parties are not bound by the solutions and reach an agreement themselves. The decision is not binding unless a deed of settlement is signed, unlike mediation. And similar, the conciliation process reduces cost, time, and inconvenience for parties. Conciliation is used primarily by CAV and also through VCAT through compulsory conference in order to allow parties to reach an agreement themselves prior to that final hearing. Similar to mediation, it's suitable where parties want to maintain good relationships and have some guidance from a conciliator, however not suitable where there is an animosity between parties or an imbalance of power. Finally, arbitration is where parties present their case before an independent arbiter who makes a binding decision. Arbitration is more formal than conciliation and mediation, however less formal than courts, as there are no rules of evidence and procedure. Unlike mediation and conciliation, legal representation is required and used a lot of the time. Arbitration is used by the Magistrates Court for claims less than $10,000 in order to save court resources, and also through VCAT in its final hearing. Arbitration is suitable where parties there's a conflict between parties or animosity or an imbalance of power, as ultimately the parties don't reach the agreement themselves. They don't need to compromise. It's the third party who makes the final decision, and they can resolve that conflict more easily. And also where parties want a binding decision. However, it's not suitable where parties want control of the decision, because the decision is made by that third party, and parties are only responsible for presenting the case before that independent arbitrator. Now we move on to remedies. Remedies are the way in which the court recognises the plaintiff's rights and legally ends the dispute to resolve it entirely. The purpose of remedies is to restore the plaintiff as far as possible to the position that they were in before the wrong occurred. One way that the purpose of damages can be achieved is through damages. Damages are an amount of money awarded to the plaintiff to be paid by the defendant. The purpose of damages is to compensate the plaintiff for any loss that they've suffered and return them to the position that they were in before the defendant caused them harm. There are a few different types of damages. The first type is compensatory damages. So they are damages that compensate for loss. So under compensatory damages, we have specific and general. Specific damages are precise monetary value, which is easily quantifiable by the court. So anything which has a receipt, such as medical expenses, psychologist fees, time off work, hospital fees, that kind of thing. So things where you can precisely quantify how much loss the plaintiff has actually suffered. General damages are also provided through compensatory damages. However, these are estimated by the court. So these are things where the court cannot easily provide a monetary value on that type of loss. The court has to consider the long-term consequence on the plaintiff, any future loss of wages, pain and suffering, both past and future. Because it's very hard to put a precise monetary value on 50 years of pain and suffering with a illness or an injury. Aggravated damages can be awarded on top of compensatory, specific, and general damages if the plaintiff has caused humiliation and insult by the defendant. So in order to even further compensate the plaintiff, those can be awarded in addition. Moving out of compensatory damages, we have nominal damages, which is where the plaintiff wants to make a point about being legally right and having their legal rights infringed, but they don't actually seek a large sum of money in compensation. This is usually used by celebrities or people who don't actually need the financial settlement and are more concerned about restoring their reputation. Contemptuous damages is where the plaintiff has a legal right, but not a moral right. So they don't actually deserve the compensation from the defendant. So this would be potentially if you were shoplifting and you tripped on the floors of the shop because they weren't mopped properly. Technically, you could sue for breach of occupational health and safety hazards, but you don't have a moral right because you were shoplifting in the first place. And finally, exemplary damages. These are awarded when the court wants to deter and punish the defendant, where they have extremely violated the plaintiff's rights. So where they've acted cruelly and in complete disregard of the plaintiff's rights. Another way that the purposes of remedies can be fulfilled is through an injunction. An injunction is a court order that directs someone to stop doing a certain act or forces them to do a certain act. The purposes of an injunction is to rectify and fix the situation caused by the defendant. There are two different types of injunctions. One type is restrictive, which is ordering a person to refrain from undertaking a certain action. So you might get an injunction to prevent your neighbour from pulling down the fence, or prevent a family member from visiting a child, or prevent the council from ripping down a house. The other type is mandatory, and this is where the court order forces somebody to do a particular act. So usually forcing a party to perform their obligations under a contract. Now we move on to factors. So as we said for criminal, this isn't a big part of the area study. And it's just something that I would just have in your notes, an idea you could talk about for something that increases cost, time, and accessibility, and one thing that reduces cost, time, and accessibility. And these are all things that we've already spoke about throughout the area study. For something that increases costs, you could talk about legal fees and court filing fees and how that reduces access and equality. For cost enhancement, you could talk about VCAT, CAV, additional dispute resolution such as mediation, conciliation, arbitration, and how they increase equality and access by reducing costs, stress, and time for parties. One time barrier is court delays, and you could talk about court delays in the civil law as well. And then the time enhancement would be case management powers, and how the purposes of the power to give directions and mediation is to streamline the case and avoid unnecessary delays. For accessibility, you could talk about communication and language barriers as a barrier to accessibility, and how that reduces access and equality for people with language barriers. And then the enhancement to access is representative proceedings, and how it allows 7 or more people to combine their claims to and therefore allow them to share the costs of legal claims, and therefore providing access to individuals who may not have otherwise been able to afford it. Finally, here are some recent and recommended reforms that you can put in your notes and research further. For recent reforms, we have the 3-tiered system in VCAT. So this allows healthcare card holders to pay a reduced filing fee, which is capped at $150, and that fee is a lot higher for businesses. That upholds access and equality by ensuring that individuals with low socioeconomic status are not disadvantaged. Another recent reform you can talk about is the High Court appeals and also Court of Appeal, whereby appeal applications are now on paper and not an oral hearing. So in order to have an appeal in the Court of Appeal or High Court, previously you had to attend court and it was a whole day hearing, whereas now you just provide an application on paper and they review it in their own time and get back to you, which reduces time significantly. Another example is technology and civil litigation in the Supreme Court, which improves access, especially to individuals in remote and regional areas of Victoria. And 2 recommended reforms. One is increased access to self-represented parties for civil through plain language guides, so removing legal jargon and language from all court documents and court resources, and also increased access to interpreters for Indigenous people in order to promote access and equality. So that brings us to the end of Unit 3 and the end of Unit 3 Area Study 2. I hope that this has been helpful, and there are questions in the note sections in order to complement what we've learned today.